Hello, I'm Patrick Miyake, and I provide legal advice that helps public agencies in California achieve their policy and business objectives by figuring out a way to say yes to their questions. Every month, I will answer a legal question relating to governmental agencies. Now, on to this month's question.
Hi, Pat. As we approach the upcoming November election, what can a public agency do in connection with a ballot measure?
In sum, a public agency, its directors, and employees may not use the public's time, money, or resources to support or oppose a ballot measure. The rationale for this prohibition is to avoid using public resources to influence the electoral process and undermining its fairness. A public agency may use the public's time, money, and resources to evaluate a ballot measure and its impacts on the public agency, to prepare a resolution to take a position on a ballot measure, or to prepare and present informational or educational materials that are objective, impartial, and factual about a ballot measure and its effect on the public agency and its customers. The informational material must be a fair and balanced presentation of the facts to assist the voters in reaching an informed judgment about the ballot measure. The line between informational material and material that advocates for or against a position is not always easy to draw. The California Supreme Court has rejected the position that all materials and activities that do not involve express advocacy are informational materials for which public funds and resources may be expended. In Vargas versus City of Salinas, the court affirmed the standard established in another Supreme Court case, Stanson versus Mott, that determining whether the use of public resources in connection with a ballot measure is proper or improper depends upon careful consideration of such factors as style, tenor, and timing of the material, and that no hard and fast rule governs every case. Therefore, for activities that are not clearly express advocacy or informational materials, the activity will need to be looked at in its entirety. For example, type of activity, content, method of distribution, and timing, to determine if it is advocacy or informational. Public agency directors and employees may engage in activities that promote or oppose a ballot measure so long as those activities occur on their own time and at their own expense, or at least not at the public's expense. It is important that public agency directors and staff comply with these laws because a violation could result in criminal and civil penalties for the misuse of public resources. Thanks for listening. If any of you watching have questions, please email them to me and I will consider it for a future segment of A Few Minutes with a Public Agency Attorney. We're adjourned until next month.